Well, it is official. The Rachel Maddow defense
has been confirmed on appeal.
VIva Frei, Montreal litigator turned YouTuber, and for those of you who may not be sure, I am saying Montreal litigator as in Montreal, Quebec, and not macho litigator. Well, there have been some developments in the OAN defamation lawsuit against Rachel Maddow, Comcast, and other corporate defendants, and yes, lo and behold, the Rachel Maddow defense has officially been confirmed on appeal. For those of you who have been around the channel for long enough, you're already familiar with the facts at issue here. I did a bunch of vlogs breaking down the original defamation lawsuit, breaking down some inter-attorney correspondence, but for those of you who may have been living under a judicial rock for the last year, OAN was suing Rachel Maddow, Comcast, and another corporate defendant for defamation for a bit Rachel Maddow did in which she called OAN really, literally Russian-paid propaganda. Relying on an article from the Daily Beast which detailed how a reporter at OAN had once been employed by Sputnik, Rachel Maddow said not only that OAN was Russian-paid propaganda, not only that they were literally Russian-paid propaganda, but that they were really, literally Russian-paid propaganda. OAN sued Rachel Maddow, Comcast, and another corporate defendant for defamation, arguing that the statements were defamatory per se, meaning that the statements were defamatory on their face by referring to OAN as really, literally Russian-paid propaganda. And Rachel Maddow, in her defense, both through inter-attorney correspondence and on the record, said that no reasonable person would take Rachel Maddow's statement to be a statement of fact, that everyone would take it to be a statement of opinion, and therefore it could not be defamatory in that it was a statement of opinion and not a statement of fact. And lo and behold, the lower court actually accepted this argument, said that no one would take Rachel Maddow's statements as a statement of fact, rather that they would know that it was hyperbole, exaggeration, her own opinion, and thus was born the Rachel Maddow defense. When Rachel Maddow speaks, she does not speak statements of fact, she speaks statements of opinion. Rachel Maddow's news show is in fact not news, it is pure opinion, and thus a meme was born. Rachel Maddow and Comcast filed a motion to dismiss in virtue of California's anti-SLAPP laws, that is to say strategic lawsuits against public participation. Their motion was granted, the lawsuit was dismissed with prejudice, and OAN appealed that decision, and the Court of Appeal confirmed or affirmed the lower court decision. It is a relatively short decision, but it does raise some very interesting questions of law, which we're going to go over so that you, the viewer, can truly understand what is going on. But before we go over the questions of law, let's just get the big spoiler alert out of the way early. Opinion: M. Smith, Circuit Judge. Appellant Herring Networks, Inc., Herring, appeals the judgment of the District Court granting Appellee's anti-SLAPP motion and dismissing Herring's defamation suit with prejudice. We have jurisdiction pursuant to 28 U.S.C. Section 1291, and we affirm. We conclude that the challenge statement was an obvious exaggeration cushioned with an undisputed news story. The statement could not reasonably be understood to imply an assertion of objective fact and therefore does not amount to defamation. We already knew the conclusion, and because it's an exercise we have to do whether we like it or not, just looking into the appointments of these three judges, unless I've made a mistake, one of the judges was appointed by George W. Bush, the other one was appointed by George W. Bush Sr., and the other judge was appointed by Barack Obama. So make what you will of the appointment history of these judges. Let's get into the substance of the questions of law at issue in this case. This is a case involving California's anti-SLAPP legislation, so the court goes over to describe the applicable criteria. California's anti-SLAPP statute allows a defendant to file a, quote, special motion to strike, end quote, a plaintiff's complaint and involves a two-step inquiry. Quote, to prevail on an anti-SLAPP motion, the moving defendant must make a prima facie showing that the plaintiff's suit arises from an act in the furtherance of the defendant's constitutional right to free speech, end quote. If the defendant satisfies this requirement, quote, the burden then shifts to the plaintiff to establish a reasonable probability that it will prevail on its claim in order for that claim to survive dismissal, end quote. The district court must grant the defendant's motion and dismiss the complaint if the, quote, plaintiff presents an insufficient legal basis for its claim, end quote, or, quote, no reasonable jury could find for the plaintiff, end quote. The purpose of the anti-SLAPP statute is, quote, to allow for early dismissal of meritless First Amendment cases aimed at chilling expression through costly, time-consuming litigation, end quote. To achieve this purpose, courts are directed to, quote, construe the anti-SLAPP statute, quote, broadly, end quote. So that is the substantive legal question at issue here. We know where the court is going to go, but there was also a secondary sort of procedural issue here in that OAN was also trying to rely on outside evidence that had not been filed with their motion in the first place, and the question was whether or not they could ex parte make a motion to include external evidence that was not filed in the lawsuit in order to counter defendant's motion to dismiss. And the external evidence that OAN wanted to rely upon that was not filed in their original motion, apparently Rachel Maddow went on the Chris Matthews show, and then again referred to OAN as Russia-owned, but came back after the commercial break to walk that statement back a little bit, and OAN wanted to invoke that additional evidence, external evidence, to counter the defendant's motion to dismiss, to allege that it was in fact defamatory, and Rachel Maddow knew that the statements were false. The court ultimately did not allow OAN to admit this additional external evidence. They said it wouldn't have changed anything anyhow because the defendant's motion to dismiss was based on law and not on evidence, that OAN apparently had not made a motion to amend or requested the inclusion of external evidence, but even if they had allowed that external evidence, it wouldn't have changed anything as a pure matter of law. And then we get into the findings of law. It is undisputed that Maddow's challenge speech was an act in furtherance of her right to free speech. Therefore, the first step of the anti-slap analysis is satisfied. The only remaining question is whether the district court erred in holding that Herring failed to demonstrate a reasonable probability of prevailing on its defamation claim. And then the Court of Appeal proceeds to affirm and ratify the Maddow defense. We agree with the district court's conclusion that the broad context of Maddow's show makes it more likely that her audience will, quote, expect her to use subjective language that comports with her political opinions, end quote. It seems Herring agrees with this conclusion as well. Herring's complaint characterizes Maddow as, quote, a liberal television host, end quote, and MSNBC's cable programming as, quote, liberal politics, end quote. You always know you're in big trouble when the court tries to use your own words against you, but I would argue that there is a big difference between referring to Rachel Maddow as a liberal host, between referring to MSNBC as a liberal channel, versus saying that they have the authority as a result of that in order to make factually incorrect statements about people. It is not because they are a liberal network that they get to make factually incorrect statements, but here what the court is basically saying is that OAN seems to recognize that because they are a liberal network, they are going to skew things with a liberal spin. Agree or disagree with it, that is what the court says, and at the end of the day, all that matters is what the judges say. The general context of Maddow's statement, therefore, quote, negates the impression that she implied a false assertion of fact, end quote. Maddow, quote, fairly described the general events involved, end quote, in the Daily Beast article, and, quote, offered her personal perspective about some of its ambiguities, end quote. A reasonable viewer would be able to differentiate between Maddow's commentary and the actual news she is reporting. And this is something I said in my original assessment of the lawsuit. I did say that I found these statements to be objectively defamatory, but I did say that there might be an argument to be made here by the defendants that by virtue of the fact that that reporter, Ruse, was in fact at one point in time paid by Sputnik, that there will be sufficient truth to the statement that they are quite literally paid Russian propaganda, because even if OAN is not Russia-owned, at the very least one of their reporters was in fact remunerated by a Russian-owned network. And so I did say that the defendants might try to raise this argument on the merits, however, in order to argue that there's sufficient truth to the statement to justify the hyperbole, but it looks like they made this argument on a motion to dismiss and succeeded nonetheless. Maddow's use of hyperbolic rhetoric bolsters this conclusion. Quote, loose, figurative, or hyperbolic language negates the impression, end quote, that the contested statement is an assertion of fact. Like it or not, agree or disagree, because I know a lot of you out there are not going to agree, the court comes to the conclusion that Rachel Maddow, on reporting on the Daily Beast article, was sufficiently accurate as relates to the facts alleged in the Daily Beast article, but she used her own hyperbolic rhetoric to then go on to say that OAN is really literally Russian paid propaganda, and that no one would take that to be an assertion of fact, only her exaggerated hyperbole. I tend to disagree. I think a lot of Rachel Maddow's viewers would take that statement quite literally, but
alas, I am not a judge on this particular court.
The court then addresses what it refers to as the far closer question as to whether or not the lower court was justified in dismissing the lawsuit with prejudice, because you will all recall that dismissing a lawsuit with prejudice means that the plaintiff cannot amend their lawsuit or refile their lawsuit. They are basically precluded from filing a lawsuit on those facts ever again. A much closer question is whether the district court abused its discretion in dismissing Herring's suit with prejudice. The district court concluded that there was, quote, no set of facts that could support a claim for defamation based on Maddow's statement, end quote, and dismissed the complaint with prejudice. Herring contends that the court's conclusion was inconsistent with its refusal to consider Herring's evidence. Quote, for the district court to find that Herring's evidence would make no difference, the district court needed to consider that evidence, which it did not, end quote. In response, Maddow argues that the district court acted within its discretion by dismissing the complaint without leave to amend, specifically because Herring never asked for leave to amend. Now, these seem to be questions of procedural California law that I am in absolutely no position to speak to. OAN is faulting the court for having not considered external evidence that was not filed in its original lawsuit. The defendants are saying OAN never even made a motion to amend to include that external evidence, and the court ultimately comes to the conclusion that it didn't even matter if OAN even included that evidence. It wouldn't have changed anything as a pure matter of law. We agree with Maddow. The district court did not abuse its discretion in dismissing the complaint without leave to amend because Herring never asked to amend, and if it had, amendment would have been futile. Moreover, contrary to Herring's briefing, the district court's rejection of Herring's evidence, given the applicable rule of... Yes, what is it, sir?
There's poo.
Poo where?
In the living room.
Okay, I'll be there in 5 minutes, please. Don't let anyone step in it. I'll be there after I'm done with my video. See you soon. There's poo in the living room. I just hope it's dog poo. Moreover, contrary to Herring's briefing, the district court's rejection of Herring's evidence given the applicable Rule 12b-6 analysis is not inconsistent with its conclusion that such evidence would not make a difference. Evidence can be both improperly proffered and unhelpful. Thus, despite our, quote, policy that favors allowing parties to amend their pleadings, end quote, the district court's dismissal with prejudice was within its discretion. And then the conclusion that will live on forever. Conclusion, Maddow's statement is well within the bounds of what qualifies as protected speech under the First Amendment. No reasonable viewer could conclude that Maddow implied an assertion of objective fact. The judgment of the district court is therefore affirmed.
Affirmed.
There you have it. The Maddow defense is now not only a part of internet lore, it is a part of internet law. And if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
Marge, I'd like to be alone with the sandwich for a moment.
Are you going to eat it?
Yes.
In fact, if you've watched until now and you have not yet subscribed, I don't know what I have to do to get you to subscribe. But that being said, Robert Barnes and I do weekly live streams every Sunday. We will be discussing this next live stream. We also do weekly streams with a guest every Wednesday called The Sidebar. If you want to find us and support us on Locals, you can find us at
VivaBarnesLaw.locals.com.
My content is also on Rumble, so you can find me there. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.